Most insolvency practitioner appointments are corporate, so relating to the liquidation, administration or receivership of a company. So at some point in time, the management, the owners, the directors will realise that the company is not going to be able to avoid insolvency. So that might be as a result of them getting some advice from their accountants, from solicitors. They might do some research on the web. And basically they, or one of their major creditors, for instance, one of the banks might appoint an insolvency practitioner or a restructuring expert to actually advise the client. So ultimately, the insolvency practitioner gets their work from a myriad of different sources. It might be just as straightforward, somebody searches insolvency practitioner on the web. The choice is to a certain extent yours if you take the initiative. So as an owner, if you actually approach an insolvency practitioner, then invariably that insolvency practitioner will end up dealing with your insolvency. However, if a creditor has to take steps, then they will introduce an insolvency practitioner of their own choosing. And that could be either somebody to go in to do a restructuring report, or somebody to be appointed as receiver or as administrator, or alternatively apply to court for the winding up of the company. The routes for people in personal debt, creditor recommends that they need to review their financial position, and it should be noted under the recent changes to the consumer credit law, there is an obligation on financial providers to refer individuals that are in excessive hardship to financial mentors or the budget advice services, or to refer them to Money Talks, which is an online and phone platform. The creditors will invariably tell individuals to get some advice, or again, friends or family might tell people to, or alternatively they might look on their web to see what help might be available, or Facebook, social media advertising, all of those things. But there is a lot of help and support out there. It's just knowing where to go and how to find and get access to it. I mean, insolvency is basically, there's two, and this applies to companies and to individuals, there's two specific ways of defining insolvency. There's a cash flow test, i.e. your income and is exceeded by your outgoings, basically. So you're in a cash deficit every week or every month. There's also an insolvency on the basis that your assets are less than the liabilities that you actually owe, which is a balance sheet test of insolvency. So there's those two different definitions, and it applies really to corporate and to individuals. The Restructuring, Insolvency and Turnaround Association of New Zealand and the Chartered Accountants of Australia and New Zealand came together to create an accreditation framework. So myself and many others were actually became accredited insolvency practitioners under a voluntary regime. Because we took those steps, the government finally recognised the need for formal regulation. So they introduced the Insolvency Practitioners Regulations Act. It came into force on the 1st of September 2020. So as of that date, all insolvency practitioners have to be licensed insolvency practitioners. They have to prove that they are satisfactorily competent, that they've got the qualifications, they've got the experience, they've got that they are fit and proper. It's putting a framework about competency and experience in place. And to become an insolvency practitioner, you have to go through that. So you're looking at 5 years of formal insolvency experience before you could become licensed. 3 years at a higher level, and certain hours of thresholds that you have to be undertaking work for. So there's quite a lot of burden of proof, effectively, to satisfy the regulators that you're competent to do your work. And then in addition to that, you have to maintain continuing professional development. You have to have professional indemnity insurance. So all of these things effectively come together to make sure that you as a director or as a shareholder know that actually the person that you're talking to are going to actually deal with you appropriately, and they're going to look after your interests and they're going to look after creditors' interests. Well, I've been campaigning for it now since I arrived in New Zealand, which is 15 years, so I was heavily involved on the board that created the accreditation regime. and been involved, through various stages of sort of development of the regulations and that. So I'm really pleased that it's come in. I think it needs to be there. There has been a lot of poor performance by a lot of people over a long period of time. So it can only be good for the industry.